while setting aside the remission granted to the convicts in the Bilki's Bano case, the Supreme Court on Monday, January 8, stressed that in protecting the rule of law, those concerned with it must remain unmindful and unruffled by the ripples of consequences. It also categorically stated that compassion and sympathy have no role to play where rule of law is required to be enforced. The 11 convicts who were sentenced to life imprisonment for multiple murders and gang rapes against the backdrop of the 2002 communal riots in Gujarat were released by the Gujarat government in August 2022 on Independence Day. The top court, however, has now ruled in favor of Bilkis Bano, a gang rape survivor who had filed a writ petition assailing the remission granted to them. In a significant win for Bilkis and other public interest litigants in the case, a bench of justices held that the state of Gujarat lacked jurisdiction to decide on remission as the trial took place in Maharashtra. Consequently, the remission orders were declared invalid and the court directed the convicts to surrender within 2 weeks. The court's pronouncement delved into the delicate balance between the rule of law and individual freedom. It emphasized that personal liberty is a fundamental right enshrined in Article 21 of the Constitution, but equally crucial is the adherence to the rule of law. The judges pondered whether the scales of justice should tip in favor of preserving rule of law or safeguarding personal liberty obtained through a breach of the law. They grappled with the question of whether the convicts having obtained freedom through an order declared invalid should be sent back to prison. When a person's liberty cannot be violated in breach of a law, can a person's liberty be protected even in the face of a breach or violation of law? In other words, should the rule of law prevail over personal liberty of a person or vice versa? Further, should this court weigh in favor of a person's freedom and liberty even when it has been established that the same was granted in violation of law? This is a case where the convicts have been granted liberty and have been released from imprisonment by virtue of the impugned orders of remission which we have declared and quashed as wholly without jurisdiction and non-est. Having quashed the orders of remission, should they be sent back to prison? Whether they must have the benefit of their liberty despite obtaining the same from an incompetent authority with the aid of an order of this court obtained fraudulently and therefore the same being illegal and carry the stamp of being a nullity and non-est in the eye of law. This has been a delicate question for consideration before us. Despite the convicts enjoying liberty for several months due to the orders under challenge, the court ultimately held that once they were found to be illegal, the natural consequences would follow. The rule of law is the essence of governance and democracy and must be preserved and enforced by the courts, the court maintained while rejecting the contention put forth by the convicts' lawyers that notwithstanding any error in the remission orders which may lead to their being quashed, the liberty of the convicts ought to be protected in exercise of Article 142 powers.